Martin. I co-chair our insurance-linked securities group. One of the things, work I do a lot of is life settlements related. In fact, for 4.5 years, I helped run a provider company, Mr. Freeman's Habersham Funding. So you could say that I learned everything I know from him. So today, I'm going to be talking about advisor liability and fiduciary duty. Would like to say at the outset that I was not the original presenter for this. I agreed to do this at the last minute. So I apologize in advance that I did not have a great deal of time to prepare these slides. In fact, I did most of it this morning. That said, so if you're an advisor who is not a broker, can you be involved in life settlements? So let's look at what a broker is by definition. I just took the Georgia statute. A life settlement broker means a person who, on behalf of an owner and for a fee, commission, or other valuable consideration, offers or attempts to negotiate life settlement contracts between an owner and providers. If you fit into this definition, you have to be licensed. And if you're not licensed, you're breaking the law. You can be sanctioned. You can have a C&D issued against you, etc. However, almost every, and I believe actually every state that regulates life settlements has an exemption in the statute, and I used Connecticut's for an example here, that broker does not include an attorney, CPA, or financial planner accredited by a nationally recognized accreditation agency retained to represent the owner whose compensation is not paid directly or indirectly by a provider or any other person except the owner. So there are ways that if you are not a licensed life settlement broker, you can still participate in a transaction and get paid. So by definition, if you're an attorney, CPA, accountant, or CPA or financial planner, you can fit within that exemption if you meet the other requirements. What is a financial planner? Well, presumably it's any of the alphabet soup of certifications that are out there. And in any event, if I've missed some here, they have to be accredited by a nationally recognized accreditation agency. What precisely does that mean? Couldn't tell you. I doubt it's ever been challenged. But if you're just somebody, if you run a business out of the back of your garage giving financial advice, probably you're not going to fit within the statute. Oops. What did I just do? There we go. Part of the requirement in the statute is the professional advisor has to be retained. So if you're an attorney you're approached by someone who says, hey, what about this life settlement stuff? And you proceed to work with them, you never actually are formally engaged, arguably you would not fit within the exemption. So you really need to enter into an engagement that's consistent with your regular engagement practices, and it's strongly recommended that you do it in writing. So that if you're ever challenged, if for whatever reason, somebody who is licensed as a broker wanted to do that case and they turn you into the state insurance department, you can say, no, look, I was engaged by these people, I'm an attorney, and I meet the rest of the requirements that we'll talk about here in a second. Payment. The compensation can't be paid directly or indirectly by a provider or any other person except the owner. And the idea there is they don't want providers going around saying, hey, if you send people my way, I'll give you a little something, something. That would not be in the client's best interests. So it's set up so that the policy seller has to pay the advisor. Now, can the policy seller use the proceeds from the sale to pay the professional advisor? I see absolutely no reason why not. I mean, that's their money once they've received it, and if they want to pay their advisor, that's fine. And some other requirements, and of course, this is like everything else with life settlements. It's all state to state, and virtually every state has some variation. In Arizona, for instance, they have the additional requirement that the financial planner or advisor has to be retained in the type of practice customarily performed in that professional capacity to represent the policy owner. So for instance, an elder law attorney who works with seniors, assisting them with financial and long-term care related matters clearly qualifies. However, if the attorney's main practice focuses on environmental law, and suddenly they're going to start doing life settlements, I think it's questionable whether the exemption would apply to them. Some other requirements, some states have outlier requirements. If compensation is paid in Maine, Mississippi, and New York, the compensation has to be paid regardless of whether the settlement is affected. So if you're engaged as a lawyer, it can't be contingent upon the deal closing that you get paid. Same thing as a CPA or financial planner. In West Virginia, the settlement activities have to be incidental to the professional practice of the attorney. So if you're somebody like myself who, life settlements, thank you very much. Life settlements is a significant portion of my practice, and I was in West Virginia, I don't think I would qualify for that exemption. Okay, suitability. Particularly when you're dealing with, I wouldn't so much apply this to attorneys, but financial planners. Even if there's no formal requirement that you sit down with your client to make sure that a life settlement is suitable for them, it just makes sense. You want to make sure that it's appropriate for their financial needs, for their health, and that it's the best option for them given what's out there. And again, it's strongly recommended that this be documented. Reason being, if somebody comes back several years later, their kids come back and say, why did you recommend this? Why did you help my mother or father do this? You can say, well, we talked about it, and it seemed like the best thing to do for them under the circumstances. Okay, so the fiduciary obligations. A fiduciary duty, for those of you who don't know, it's a legal duty to act solely in another party's interests. You can't profit from your relationship with the principals unless you have their express, informed consent. And you also have a duty to avoid conflicts of interest between yourself and the principal. And it's the highest duty recognized, highest duty of care by the US legal system. So if you're a fiduciary to a client, you must absolutely do what's in their best interest, or you can be liable to that client. Do life settlement brokers have a fiduciary obligation to their clients? Yes, clearly, statutorily in most states, to act only on behalf of the policy owner, to get the owner the best offer, etc. Attorneys, again, absolutely yes. We have a fiduciary obligation to act in the best interest of our clients. Would this apply when we're assisting with a life settlement? I would say yes. If I am representing my client in a life settlement, I would think that I would have to act in their best interests. With respect to CPAs, it gets a little bit more complicated. This was on the AICPA website. It says, while an accountant normally is not considered to be a fiduciary to his or her clients, the AICPA Professional Code of Conduct embodies standards of conduct which are closely analogous to a fiduciary relationship. Objectivity, integrity, free of conflicts of interest, and truthfulness. So even if you don't have a legal fiduciary obligation to the client, you might be accredited by an organization that imposes a similar duty on you. Now the question would then arise, is there a private right of action? So if you're a CPA and you assist a client with a life settlement transaction and you just screw them over, you act completely in your own interest, they eventually find out about it and come after you, can they say that you had a duty to them? Now, I think what courts would likely do is they would look at the relationship, and if you've got an older person who has this policy they don't want or need, or maybe they do still need it, and you tell them to sell it and you take 50% of the offer price, I suspect strongly that a court is going to find, and let's forget about the Grill case for a moment, which we'll talk about, I suspect strongly the court is going to find you had some duty or obligation to that person, if only a duty of good faith and fair dealing, which they would probably say is a basis for your liability. Other financial advisors. Again, even if there's not a legal fiduciary relationship, you could still face liability if you affirm, this is around the duty to disclose. So let's talk about that for a second. If you have a fiduciary obligation to your client, and you know that life settlements are an option, and you choose for whatever reason not to disclose this to a client for whom it would be appropriate, it is entirely possible that you could have liability. That's really the principle that the Grill case stands for. So talking about the Grill case, The policy owners allege that they could have settled their policies if they had known about the option rather than surrendering $5 million or whatever it was of face. What was really important about this, and I think most of you probably know this if you heard the attorneys on this case speak yesterday, that this is the first time a court has affirmatively found that there is an obligation, a duty to disclose based on partial representations. On the motion to dismiss, the court said the plaintiffs have sufficiently alleged a duty to disclose based on partial representations by alleging that defendant's agent represented that they had two options and concealed the life settlement option. So a motion to dismiss, for those of you who aren't lawyers in the room, that just says, the plaintiffs filed a complaint. Lincoln took a look at the complaint and said, you know what? We think even if what you're saying is 100% right, you haven't alleged a cause of action. You can't sue us for that. We didn't have any duty. There is no duty to disclose. And what the court said was, no, hold on a minute. We think there is a duty. And if you didn't tell them about it, then you have violated that duty. Now, that doesn't mean that they're going to be able to prove it. It doesn't mean that they win by any stretch, but it survived the motion to dismiss on the pleadings. So what the court specifically concluded was that they had sufficiently alleged a claim under the unfair competition law on the basis that, as a general matter, elder citizens are unaware of the option of a life settlement, that the defendant, the carrier, has a practice or policy of concealing the option from such citizens, and that there is no utility or countervailing benefit to the defendant's conduct. Faced with those facts, the court concluded, the court agrees that there does not appear to be any utility to this alleged practice. That's the failing to disclose the life settlement option, but the possible monetary harm to the insured and policy beneficiaries is clear. So the court's saying, if you did know about this, and this would have been good for them, and you didn't tell them, you could absolutely be liable for the failure to do so. What's interesting about that, though, is insurance agents don't have a fiduciary obligation to the insureds of the policy owners. To the extent they have a fiduciary obligation, it's to the carrier. So the court found the existence of this duty, even in a situation where you don't have that special fiduciary relationship between the agent and the principal. So if the court found it here, I strongly suspect that if it looked at a different type of relationship, the CPA type relationship, obviously the attorney relationship, they would say yes. If you knew about this, and under those circumstances, you should have told them that there would be liability. So what's at stake for you as advisors? There's potential monetary liability. You could lose your accreditation, licensure. So bottom line, is a matter of prudence and good practice. Disclosure of the life settlement option just makes sense. So in this room, what do we got here? I know that there's several attorneys. Are there any life insurance agents? Okay. What about accountants, financial planner types? Have you ever assisted a client with a life settlement? And so are you licensed as a life settlement broker? No. Okay. Is it, based on this presentation, is it clear to you that how you could assist a client with a life settlement if you were in a position to do so? Yes. Okay. So as I said, and that was the whole presentation. That's as much as I had time to prepare. Are there any questions? Anything you'd like to discuss?
Jim, what you just said is generally, Jim, I'll start over. What you just said about the agent, an insurance agent being the agent of the carrier, is generally accepted. However, as you know, it really could be fact-based and contractual. And in some instances, some of these, especially these carriers that want to do brokerage and don't really have career agents, in fact, they may, by contract, have you not be the agent of theirs. And so, and by the way you advertise, you might actually be the agent of the client. Because if you say, I'm out to get, I'm out to be your your agent, I want to do what's right for you, I'll shop the market. By what you say, you actually could be, couldn't you? And if that is the case, then you may be somebody, even if they're not acting as a settlement broker, maybe they do have a duty to that person to tell them about life settlements.
No, I think that's right, and I think that that's one of the principles that the Grill case stands for, is that if you have a relationship with a client, even if it is not a fiduciary one under the law, that something that you could easily tell them about, that your failure to do so or the affirmative decision not to tell them could harm them monetarily, that there's a duty to disclose it. Any other questions or comments? Okay, well, I think that wraps it up.
One more.
So I'm not an attorney, so I just want to know, with the Larry Grill case, if it does side with the client, what kind of impact do you see? Would it be very sudden and kind of see life settlements take a jump up, or do you think the other states would have to follow it?
Yeah, so in order for the carriers to feel sufficiently incented to affirmatively disclose life settlement, somebody's going to have to get smacked with a huge verdict. And even then, I suspect the affected carrier would modify its behavior, but it doesn't mean that the other carriers necessarily would. Now, if they didn't, you'd see class actions against them as well, because that's the other thing to keep in mind, is that this is a class action. So they're trying to certify a bunch of people who have are in a similar situation and potentially suffered the same injuries by withholding that information. There are, in fact, 6 states that do have mandatory disclosure laws. 5 of them, I can't recall if they actually require I know that they're required to tell you that there are alternatives to surrendering your policy. This is for the carriers. I can't recall, Brian, do you recall if they're actually required to say that a life settlement is an option? Yeah. They are, okay. And then there's one state that just is required to say, oh, by the way, there are alternatives, but they're not required to say life settlement. But if it did get to the point where the carriers felt incented that they needed to disclose to insureds who were, not just surrendering. If you think about when an individual files for an accelerated death benefit, and the carrier looks at the medical records and says, nah, I don't think you have 24 months to live. I think you have 30, for instance. If at that point they were required to tell the policy owner, you can't take advantage of the ADB clause in your contract, but there's this other option out here, I suspect we would see a lot more policies coming into the market. And hopefully that will be an upshot of this case eventually. It'll be several years before the case is, fully comes to fruition, and assuming that the plaintiffs win, before the carriers would actually do anything. And I suspect, this is just pure speculation on my part, that a carrier, if they think they're getting to the point where they could actually lose this, or if the class gets certified, they would probably settle. So there wasn't the law on the books that in fact we're liable for having done this, and that would be a way around, having to then disclose. And each carrier then would have to be sued, and it would take several years. So really the best fix is legislative. And there was for a while some appetite, I think it was really driven by Coventry, that was funding the lobbying effort to get states to enact mandatory disclosure. And I'd be interested, Brian or John or other providers in the room, it's Oregon, Maine, Wisconsin, Kentucky, and okay. Have you been seeing any more policies out of these states? Washington, yes? Okay. And do we know that that the carriers are actually doing it? Have you seen evidence that the carriers are in fact? How about you, Karen?
I've heard. I've actually talked to sellers that have called me personally because my name is on the license.
Yeah.
And they call the Department of Insurance to find a list of providers because they got this notice.
Okay. Well, that's good to know that they're actually, following the law. Well, and that's something, I would say to all of you, that to the extent that you have, contacts in your home states with legislators, talking to them about this, getting the word out that life settlements really are good for the residents of their states, and trying to urge them to run with that, to enact legislation that requires carriers to let insureds who are going to surrender or want an ADV, that this is an option for them.
So in Georgia, just so you know, because I've talked to our folks in Georgia about this, and I probably forget it, I don't now. So in Georgia, I want to just tell our folks in Georgia that there actually is some will to do this in Georgia right now, and frankly, I haven't had time to really follow it up, but maybe we need to get together when we get back home, because there are some both senators and representatives who would like to see this passed that we've been talking to over the last few years, and so maybe we could push this thing through and starting in the legislative session that starts in January.
Yeah, I mean, if you think about it, really, what an extraordinary coup for the life carriers, that they have been able to not disclose something that is good for consumers with their product. The life settlements industry has been painted for a number of years as rascals and so forth, when really it's the carriers that are withholding this information. Yeah, it's interesting when you look at it. It's humorous. Well, any other questions? Oh, yeah, please.
If the market does increase exponentially, will that ultimately change the pricing of life insurance contracts? Fewer lapses, fewer policies where someone takes out cash surrender value?
Yeah, I think first, to address the term exponential, I don't know that it can increase exponentially. I think it could increase, and I think exponentially literally means by exponent to double. Yeah. I don't know that there are really enough policies out there. I mean, right now, I believe that the life settlement industry is little more than a rounding error in the, however many trillions in face that are in force. And the lapse-based pricing, as I understand it, was always sort of a shibboleth that the carriers threw out as, oh, it's going to affect our lapse-based pricing, when a lot of carriers have shifted away from that anyways. At least that's my understanding. I'm not an actuary. So, Wendy, I think the answer is that carriers might, sort of cry Pollyanna about it, but that it ultimately isn't going to make a big difference in the pricing. There's not enough of it. That's right. I mean, if we were a $2 trillion market, yes. But, by all estimates, what are we, a $2 to $3 billion a year market? And somebody in this room probably knows how much new face is written a year. I mean, it's hundreds of billions.
Yeah. Jim, we're doing some work that might demonstrate that north of $40 billion a year of policies face value are lapsed by seniors over age 65 that are actually lapsed. So, but even if you take that number against the $10 trillion of life insurance held out there by individuals, it is so small.
Yes.
That it's infinitesimal. I can't even imagine it affecting pricing if you do any kind of math at all with regards to its impact or effect. Nice thing to use
Yes.
to try to fight it, but the alternative is to plead with the insurance companies is, geez, I mean, you sold these people this product. Why don't you just do right by them by at least letting them know that they have these options on the back end? Because if you don't, some senator or representative in Washington, D.C. is going to have some, relative get screwed over by this, and it's going to become a national conversation piece.
Yeah, well, so in the best spirit of presentations at LISA conferences, we have obviously digressed onto other things. But no, it's interesting and it's important. I'm sorry, Brian, what were you going to say?
I was just going to say that, I'm involved in a bank, as some of you know, and being on the board of this bank, and really having been someone who's been accustomed to regulation in my whole career, it's interesting to see how much disclosure in every other financial product that's offered out there by most financial service industries that you have to make. And then you come to the life insurance industry and they have to tell you absolutely nothing. So, it's it's really odd, and it goes to how powerful that the carriers have been in the life insurance industry is that they've been able to keep it that way. But in the course of human history, everything always moves toward the consumer. So over time, it has moved, and I think it will continue to move so that eventually you will see disclosure.
I think that's right. And it's interesting, too. I have never fully understood the carrier's irrational hatred of life settlements. If you look at sort of the history of economic or financial instruments, how, when there is a secondary market for an asset, does it not benefit the primary market? I mean, that's just how economics works. And I was a philosophy major, and I understand that. The whole good-bad thing I'm still a little fuzzy on, but so it's interesting, and hopefully, we are starting to see a change, and it's more advisors getting involved in the industry is going to help, because eventually the carriers are going to have to accept that they do have an obligation to disclose, and that the individuals out there who deal with the clients, who buy the policies, have an obligation to disclose it as well. So any other questions? Thanks very much.
Thank you, Jim. Just a